181, matter of Kigin. Counsel, would you like any rebuttal time?
1 minute, please, Your Honor.
1 minute, sure, go ahead.
May it please the Court, my name is Robert Gray. I'm appearing on behalf of Appellant Maureen Kigin in this matter. The issue before the Court fundamentally is whether the State Workers' Compensation Board has issued a regulatory scheme that is in conflict with the statute that the Board is charged with the obligation to administer.
Why would it be in conflict? Give us your basic kernel of your argument.
The basic kernel of the argument, Your Honor, is that as it's presently written, the statute provides that the employer or carrier can deny treatment before the treatment is rendered, provided that they meet two conditions. One is that the treatment has to cost in excess of $1,000, and the other is that they must have a doctor saying that the treatment is not necessary.
Actually, what it says is a second conflicting opinion from a physician.
From a physician authorized by the Board.
Doesn't that sort of assume there's got to be a first opinion before there's a second opinion?
It assumes that there's a request from a treating doctor for treatment that costs in excess of $1,000, thus implicating 13A5.
Is the physician's opinion that that's appropriate and necessary treatment?
Yes, sir.
And why can't the Workers' Compensation Board, and you agree that that's subject to dispute, obviously, and the Board can say it's not appropriate and necessary.
Well,
you say they have to have a conflicting opinion from a doctor, maybe, of course, in this case you do.
Well, with regard to the conflicting opinion from a doctor in this case, the matter below was not decided based on the opinion of that doctor. The matter below in this case was decided based on the Board's guidelines, and the medical opinion that was proffered was also based on the guidelines. So the fundamental question here.
Why can't the guidelines be read to say, in effect, we're regulating the first opinion to which the second one is conflicting, and we're saying you've either got to be within the guidelines or show us a good reason, a good enough reason for a variance. Why is that inappropriate?
Because it's contrary to what the statute says, Your Honor.
What does the statute say about what the first opinion has to say?
Well, you'd have to read, I believe, together sections 13A, 13-A5, and 21.5. 13A establishes the broad obligation of the employer and carrier to provide medical treatment.
My question is, what does the opinion, there's clearly some implicit burden on the recipient, on the claimant, to do something. You don't just get money by saying send me a check. You have to have a doctor saying this is appropriate treatment. We agree so far?
Yes.
Why can't the Workers' Compensation Board, by regulation, define the extent of that burden? So we're going to consider an application adequate when it's either within these guidelines or shows us a good reason for being outside the guidelines.
Because, Your Honor, the legislature has already defined that burden. The legislature has already written a statute, 13A5, and what that statute says is that treatment in excess of $1,000 can be pre-authorized or pre-denied based on a conflicting medical opinion. The necessary interpretation.
Okay, but I keep coming back to it. Suppose it's $500 and the statute doesn't apply at all. You can't say, I would like $500 for a rain dance. You have to have a doctor who says, I want to give, this guy has a $500 treatment that will work.
There's a bifurcation of issues here, Judge, between treatment and payment. The way the statute is written, the injured worker is entitled to receive the treatment and the physician submits the bill. The carrier still reserves the right to dispute the bill, and then whether the bill is payable is a matter to be adjusted between the provider and the insurer. But in the interim, the injured worker has been treated. The problem with the regulatory scheme that you have here is that the injured worker now cannot get.
Wait a minute. How can the worker be entitled to treatment that no one's going to pay for? What good is that?
That's the nature of the system, Your Honor. It's been that way for 100 years. But it's better now.
I thought the benefit of these new regs is that the injured worker doesn't have to get pre-approval. The injured worker can get 10 treatments. And then if they want additional medical treatment of this nature, say acupuncture, then they've got to request the variance. So for the vast majority of injured workers, it's eliminated that first step that they've got to wait to get a medical opinion. They can get 10 treatments. Am I wrong?
There are two problems with it, Your Honor.
Is that how it works? Am I right or wrong about that?
Under the guidelines?
Yes, under the guidelines.
Under the guidelines, the injured worker gets the treatment that the guidelines prescribe.
So you get 10 treatments, and then you decide whether you want to request a variance.
Correct.
Correct?
That's the guideline
so doesn't
process.
that benefit the vast majority of people? It eliminates having to go in and get pre-approval.
The short answer to your question, Your Honor, is no, because with the increase in the pre-authorization threshold from $500 to $1,000, that sweeps in all of this treatment anyway. So when the pre-authorization limit was $500, yes, there were people that had.
You're talking specifically about this acupuncture.
I'm talking about this acupuncture or physical therapy or chiropractic.
In general, presumably there's some benefit to having a long list of procedures that the claimant doesn't have to go to the trouble of asking pre-authorization.
Indisputably so, Your Honor, and we have no objection to the medical treatment guidelines to the extent that they pre-authorize treatment. The legislature clearly directed the board to pre-authorize.
Under that scheme, though, doesn't it set up a situation where you're saying the next step makes them out of compliance with the statutory purpose?
That's exactly so, Your Honor. The portion of the guidelines to which we object is not the portion of the guidelines that pre-approves
treatment. Get 10 treatments.
It's that once the injured worker has gotten the pre-approved treatment, the guidelines now automatically pre-deny the treatment.
What would be an appropriate scheme after you get past the 10 treatments?
After you get past the treatment that's authorized by the medical treatment guidelines, whatever that is,
yes,
the appropriate scheme would be to follow the existing statutory procedure.
Well, doesn't the existing statutory procedure always make it an obligation to show that the treatment's medically necessary? So I don't understand what you mean by pre-deny.
The existing statutory procedure, Your Honor, has a presumption in favor of the request of the treating physician, and it imposes an obligation.
What would that be? That would be?
That's the Section 21.5 presumption.
But isn't 21.5 just a presumption that the facts as set out in the medical records are assumed to be prima facie?
You don't have to bring your doctor in.
Those facts would be the diagnosis, the level of disability, and the treatment request. That's the purpose of having treating doctor reports.
That's not a fact.
Pardon?
Okay.
Is the treatment request a fact?
That the treatment is being requested is a fact, yes, Your Honor.
Yeah, okay, well, no, I have no doubt whatever the treatment's being requested.
Okay.
But the question isn't whether it's requested, it's whether it's reasonable and appropriate. Is that a fact that's subject to the Section 21 presumption?
Well, if you go back to 13A5, under $1,000, there's no mechanism for the carrier to deny the treatment before
Okay,
it's
so
rendered.
Section 21 has nothing to do with it.
Well, we believe that Section 21 and the purpose of the law, which this Court has outlined in many, many decisions, is to create a presumption in favor of the injured worker and in favor of the injured worker's doctor's report.
Judge Cardozo says that that the purpose of the presumption is just to get rid of the stuff that's not controverted and not put any burden on the claimant to have to prove stuff that's not going to be fought about anyway. Isn't that right?
Correct. And the statute as it exists provides that the treatment request gets granted unless the carrier comes forward with a contrary medical opinion. The issue with the guidelines is that the board has substituted the statutory requirement that the carrier produce a contrary medical opinion with a relief for the carrier from its obligation to do that and arbitrarily deciding.
After the 10 treatments, what should happen? You come in, you say, I request whatever, and basically unless they come back and say a good reason why you shouldn't have it, you get it. The presumption is with the claimant.
The presumption and the text of Section 13A5, Your Honor.
But isn't it still with you? In other words, your doctor knows you're getting up to the ceiling, and she writes in and says, it's an ongoing treatment, and the claimant's going to need another 25 treatments. Unless somebody's got a good reason to deny that, it's not automatically denied, is it?
No, Your Honor. What happens is if it's under $1,000.
I'm over that.
But if it's under $1,000, the injured worker gets it. If the carrier then has an objection to the bill when they receive it, it goes to an arbitration panel, which is the way it's been forever. If it's over $1,000, the burden shifts to the carrier.
Okay, burden, but what I'm suggesting to you is if the doctor even picked up the phone and said, he did lose a leg, and it's going to take more than this, and so it's an ongoing treatment, no one's going to deny it. I'm searching for the, I mean.
Your Honor, having practiced in this area for 27 years, I have to respectfully disagree with you on that point.
Well, are you arguing that that there's a presumption that what the treating doctor says is required is medically necessary?
In the absence of a contrary opinion from the carrier's doctor, yes.
So in the normal course of these kind of, what happens practically? The doctor comes back and says, you see this all the time with all kinds of covered treatments. You had 10 sessions, now I need another 10, or the doctor says he or she needs another 10 to continue the progress that they've made. And then what happens in practical terms? At that point, the carrier says, wait, let me look at that, and then comes back and either says, fine, it's approved, or comes back with a contrary view of it, and then it's not approved?
I can
You know what I'm saying? What happens in practice?
I can answer that for you two ways, in the pre-guideline condition
Go
and
ahead.
the post.
Do it.
In the pre-guideline condition, if the treatment was under $500 or now $1,000, the injured worker got all of the treatment because no pre-approval was necessary. If the carrier felt that the treatment was unnecessary or that it was overbilled, they would file objection to the bills, and the billing dispute between the provider and the doctor would go to arbitration, the injured worker having already received the treatment. If the treatment request was for over $500 or now over $1,000, the treating doctor has to submit a written request, and the carrier has 30 days to either authorize it or to produce a contrary medical opinion denying it. If they deny it, then there's litigation. If they approve it, there's no problem. Under the guidelines regimen, once the injured worker has gotten the treatment that the guidelines prescribe, if the treating doctor sends in a request, the carrier need do nothing, because the guidelines have been established by the board as the quote-unquote standard of care.
You're saying that's where the presumption is flipped, or the burden is flipped, and that's the problem.
And the regulation expressly flips the presumption and says that the burden of proof is on the provider.
Is that why what didn't happen here? Because I thought, maybe I'm reading your client's doctor's submission or deposition differently, but I thought she didn't find necessarily functional improvement. It was more pain management.
That's an issue with the guidelines, Your Honor. The guidelines focus on functional improvement as opposed to palliative care. The board issued
That could last forever. So is the system required to pay forever? Is that a concept of workers' comp?
Yes, Your Honor. The claimant, the injured worker's right to medical care is not time-limited and continues as long as causally related treatment is required.
Let me ask if I could, you told us how it's supposed to work. Let's take an extreme case, a ridiculous case, but it's to make a point. My doctor's a witch, and he or she thinks he can cure my ailments by burning bats' toes in a cauldron, and he's going to charge me $5,000. And I ask for pre-approval. You're saying that the carrier has to either fork out the $5,000 or get a contrary medical opinion from a physician.
That's what the law says, Your Honor. The other point I would make to you, though, is that these guidelines are not the board's sole means of reining in what it believes is inappropriate treatment. A physician can only treat an injured worker if that physician is coded by the compensation board. The board has power over coding, and the board has power over billing disputes. So this regulatory scheme is taking a blunderbuss to a problem that requires a small.
You're probably not going to have the doctors that Judge Smith is talking about be on the coded list.
Yes, the problem is that if you have a doctor like that, they shouldn't be coded.
But
Yes.
there are doctors who are a little bit aggressive sometimes in what they're willing to charge for. Has such things happened?
Absolutely, Your Honor, and that's why the carrier has recourse to disputing the bills and going to arbitration.
And if the carrier-
If the legislature adopted this as opposed to this being a regulation guideline.
The legislature, Your Honor, certainly could have amended 13A5 to direct the board to predetermined treatment requests. The legislature did not do that. The legislature directed the board to issue a list of pre-authorized procedures with which we agree.
Part of a reform package to try to keep the costs down of workers' compensation.
Well, if you...
So I guess we'd be telling them they have to be more specific.
I believe, Your Honor, their list of desired outcomes was to remove impediments to diagnosis and treatment, to create a list of pre-authorized procedures to reflect best medical practices, to reduce litigation costs, and to increase benefits. So to the extent that the guidelines pre-authorize diagnostic tests and fundamentally necessary surgeries and basic courses of physical therapy, they achieve all of that. The problem is that the second you go beyond the guidelines, you now have a stoppage of treatment until the variance is approved.
Not necessarily.
If it's approved.
Not necessarily, right?
Yes, Your Honor.
You can anticipate that you're getting to the end of whatever the guideline is, and you can go in and get an approval before treatment stops.
Only if the variance application is granted. The problem, Your Honor,
of course.
what the regulations provide and what the board has done is if the person reaches the end of their therapy and the doctor puts in for a variance, and while the variance is pending, the doctor does the right thing and continues to treat the patient, and then the variance gets granted 6 weeks later, the board will not approve payment to the doctor for the 6 weeks of treatment that it agrees were necessary because it was performed without a variance. That's the problem, Your Honor.
Yeah.
What happens
Judge Abdissalam.
currently, because the guidelines were changed recently, I think last year, for this kind of treatment, is your client still getting 10 additional, or was she able to get 10 additional treatments?
The board issued chronic care guidelines. It still has not issued palliative care guidelines, which the board views as a distinct issue, because you go back to the guidelines focus on function. So you've got chronic care guidelines that focus on function, but we still have no pain relief guidelines.
She's not getting, if she didn't get additional treatment.
No, Your Honor. You have a lady here who's a court reporter who works and tries to work, and she needs something to manage her pain so she can show up to work for the board by whom she's employed.
Okay, Counselor. Thank you, Counselor.
Thank
you
you,
have
Your
your rebuttal. Counselor? What's wrong, Counselor, with the scheme that your adversary lays out that he says is consistent with the statute itself?
Well, I think there's a couple of things I'd like to make clear. One is
No,
this,
but what's wrong with it?
well, I think the fundamental error is I don't think the statute creates this burden, this presumption that medical care, that the claimant is entitled to any medical care.
So he's wrong as to who has the burden
Correct. Correct.
under the statute as it exists, irregardless of the guideline?
That's right. We don't think that the workers' compensation law reflects a general presumption that all that.
Isn't the presumption you get treated while you need treatment? Isn't that the basic thrust of the statute? As long as you require treatment, you get compensation.
If it's medically necessary, but there's always been this basic issue that you're only
So it
entitled
all
to
comes
care.
down to who has the burden.
Correct. Correct.
Because the assumption is you get treatment if it's medically necessary. Who shows it's medically necessary?
Yeah, I mean, clearly no one denies it.
Or unnecessary.
Is there a difference? I mean, has something changed? Or is your argument that this argument is totally specious, that nothing changed under the new Reform Act?
Nothing has changed in our view with respect to the burden of proof, which is really their main objection here, which is the only thing that's really changed. The board has provided a very detailed set of guidelines for what is considered medically appropriate care.
What was the claimant's burden? You say it's always been the same. So what is it? What was it and still? What is it that it was and still is?
Well, the claimant would have had the burden in any situation where there was a dispute as to whether or not the care was medically necessary to meet that burden and to show that the care was medically necessary.
Well, I guess you don't get a dispute until the claimant asks for something, right?
That's correct.
And the claimant, he or she has to presumably has to have a doctor saying this is appropriate. Or he can't just say, gee, I'd like to go spend a few $100,000 on whatever I feel like.
You know, that's correct. I mean, presumably the claimant would have a care provider that would say, I think you should have more acupuncture.
Is there any difference then between the two? I get the impression from your opponent that let's assume there's 10 under the guidelines and this person needs 20. And he's saying if we don't ask for it, they're going to cut us off at 10. We're done. And unless we get a letter in or something, we either can treat for free if the doctor is willing to do it because you're never going to pay them because there was no letter there on that date, or stop treatment. Is that
That's
true?
right. I mean, they can't. Is
that true before?
Well, the care provider. One thing I'd like to make clear is
Answer the judge's question.
okay. That may have been true before because, well, the care provider would have been at risk of not being paid if they proceeded with treatment that was not medically necessary. There was a possibility the carrier or the employer would come back and say that care went beyond what was medically necessary
But
in this case.
that was a risk assumed by the medical care provider. I
Correct.
think what your adversary is saying is the injured worker got the treatment that they needed, depending on whether the provider was willing to take the risk of getting payment or not getting payment or partial payment. Whereas it sounds like under these guidelines, there can be a break in treatment while the worker awaits approval of the variance if and when that may ever come.
That's right. That's correct.
So that's a substantial change.
Well,
Would that be something that the legislature approved as opposed to a regulatory act?
yeah, because the board has always had the authority to regulate not only the system generally, but to adjudicate disputes as to whether or not care was medically necessary.
Is it a good thing from a policy perspective that there be that kind of break when someone really needs the treatment?
Well, I think it's
and as Judge Grappio said, if it's not a good thing, wouldn't you think the legislature should be the one that's going to say that?
Well, I think it's important to remember that the guidelines provide to the extent they apply, provide a comprehensive summary of what's considered under current medical thinking what is appropriate care for particular types of injuries. So by
Inappropriate that you might need another 10 treatments?
well,
I mean, in the broadest context.
in the broadest context, not necessarily, but it's true that the employee or if they felt that this was an unusual situation.
Yeah, but I think what your adversary is saying is that to do it the way you contend the new schematic works is contrary to the whole purposes of the statute. Why is that not a reasonable approach to this? It would seem that all of a sudden you could need treatment, which is the whole idea of the statute, and now you can't get it under this new scheme that was not, it's not the legislative scheme. The legislative direction was you can say a certain number of treatments that are just done, but beyond that, the rest of this is not what they've laid out, is it, or is it?
Well, remember that for the great majority of cases, the employee is going to have an incontrovertible entitlement to the care that's considered in the guidelines.
Isn't it a typical?
So this is the extreme.
Isn't it a typical circumstance, let's say with acupuncture or so many other things, that you'd have the 10 treatments and you're going to need more? This is not an unusual circumstance, or is it?
Well, the point is that they're not precluded from obtaining it. They just have to show. They have to go in and say.
No, but you just could have a real break in your treatment.
You could.
Again, under his theory, your adversary's theory, that the legislature didn't say that. And now you're radically changing the way it works. And if you're going to radically change the way it works, maybe the legislature should do that and not do it by kind of this flipping of the burden that really is not a necessary consequence of these pre-approved 10, treatments. Isn't that his argument?
I think that is essentially his argument. And I can only say that I think the break in treatment probably would have occurred under the pre-existing scheme because the care provider would have been reluctant to say in many cases, I'm not sure that the comp system will pay for this treatment.
When you two are arguing about burden shifting, you say there is no burden shifting, he said there is. It really comes down to that day, right? The day that the comp board says no more treatment, and that's now regulatory. You're saying no more treatments after X, right? They're saying before when that day came, we continued to get treatment unless and until the board had a hearing or made a determination that it's no longer necessary. And before, that treatment continued, and sometimes we win, sometimes we lose, but at least the treatment continued. That's it seems to me is the burden issue that we're talking about, isn't it?
Yeah, I mean, I don't think there was ever an assurance that the
Well, does it
treatment might
depend on whether it's
continue.
more or less than $1,000? I mean, in the old days, it was more than $1,000, and you wanted your 11th acupuncture treatment, you had to get pre-approval.
Yeah, I mean, one thing
And if the carrier said no, then there was a proceeding in which different conflicting, they had to get a conflicting medical opinion, but there could be a gap at that point, I would think, even in the old days before the guidelines.
That's right, right.
But on the other hand, if it's less than 1,000, what would happen is the provider would make the decision, am I going to take my chances on giving the 11th acupuncture treatment and see if I'm going to get paid or not?
Correct.
And now the rather than the provider taking chances, the provider does an application for a variance and finds out beforehand.
Correct.
And does that make for a more drawn out process in which the treatment is more likely to be interrupted than it used to be?
Well, the regulations have an expedited procedure for resolution of these things, and one of the advantages of the guidelines and the regulations adopting them was intended to be resolving a lot of these disputes in advance by having, carefully thought out guidelines by experts as to what is and is not appropriate, as opposed to the prior system where an administrative law judge at the board would be resolving these disputes based on conflicting opinions of physicians, which led to potentially inconsistent or unpredictable results. Now there's a lot more clarity.
Thanks, Counsel.
But
Appreciate it.
thank you.
Good afternoon. I'm Jill Singer for the Special Funds. The board has always determined the medical necessity of treatment as a trier of fact. The burden of proof has always been on the claimant to show that treatment was medically necessary in the face of a challenge, and now, with the medical treatment guidelines, that challenge has been predetermined. And the variance process
He says you're not allowed to predetermine it under the statute unless you have an opinion of a physician.
Care is always needed to be medically necessary, though, or else
Well, in the
it's
old
on a
days,
case-by-case
if you had a
basis.
treatment that was more than $1,000, you had to ask the carrier, is this okay? And the carrier was not allowed to say no unless, well, assuming you started out with a physician's opinion saying it was all right, the carrier had to have a second opinion, a conflicting opinion from a physician, and that's in the statute, right?
Right, but that's
What
already...
happened to that second conflicting opinion? Does the carrier not have to get it anymore?
The carrier can get it, or the carrier can challenge on the basis that the treatment is not appropriate and medically necessary.
Yeah, but the carrier can deny it without having a second medical opinion. That's the question.
If they don't meet the burden of proof.
Under the new
If they
scheme.
don't meet the burden of proof. But it's just been predetermined. It's the
Yeah,
same-
but
Isn't that contrary to the statute? Doesn't the statute say he's got to have a doctor's opinion before he denies it?
But that doctor's opinion would be challenging what the guidelines have just predetermined. In other words, it's just shifted the timing. The burdens haven't changed.
If there were 5 treatments, the carrier could say, we're not paying anymore, we think 5's enough, and you would be saying under the new guidelines, no, up until 10, we're not going to let you controvert.
Right, it's predetermined to be, in this case, 10. In the old days, the carrier would have had to get a medical opinion, but now they don't have to because it's been predetermined by the guidelines. It just makes the system more efficient.
Yeah, but the guidelines, in essence, say if it's more than 10, then you presumptively don't get it.
Then you need
Isn't
to
that what
show-
it means? Or I think that's what it means.
Right, they're saying that's what the guidelines consider that to be medically necessary, and if you want more, then you have to...
I understand the new system might be more efficient, but isn't the old, the guidelines can't amend the statute. The statute says that you can't deny pre-approval without a second conflicting opinion from a physician. What happened to that statute?
The guidelines just determine initially what is medically necessary treatment.
You had that group
And
that studied it and put all these things in place, and that is the predetermined that it's not medically necessary after 10 in certain situations.
basically, they're laying out what is and isn't
So
medically
the question
necessary
is,
treatment.
can you do that, or is that contrary to the statute?
You
Can you say that presumptively, since we've studied it, here's the 10, this is what you get, anything more than that, presumptively you don't need it, and we don't have to put any medical evidence to say that you don't need it?
That's
The
part of the
answer to that
board's.
is yes, right? That's what the
It's under the
new
board's.
schematic does, right?
Because the board's always been the trier fact as to what is and isn't medically necessary treatment. They're just doing it ahead of time.
So
to
in
make
answer to
the efficient
Judge
one.
Pickett's question, once you do the 10, you've studied it, right? That's it. You have a right, in your view, your position is, you have a right to say anything else is no good, and I don't have to give you any kind of medical contrary evidence. You can't get it presumptively.
Right, because it's already been
Right,
predetermined.
right, that's fine. Okay, thanks. Counsel, rebuttal.
Your Honor, what that argument boils down to, which I think Judge Smith put his finger on, is the Respondent's contention is essentially that the Board believes the guidelines are a good thing. That is, as Judge Smith pointed out, not the office of the Board. The question for the Court is whether the guidelines are lawful. Otherwise, we run into U.S. versus 200 barrels of whiskey. With regard to your question, Your Honor, about whether submitting variances is an unusual circumstance, since their inception, the record at the Appellate Division will show the Board has been getting 20,000 various applications per month. So you're dealing with 250,000 applications a year from doctors who do not believe that the guidelines are adequate to treat their patients.
The alternative then would be what?
The alternative would be the system would be to uphold the guidelines to the extent.
The alternative would be that you'd have 20,000 physicians treating without authorization from the WCB, waiting for the WCB either to pay them because of oversights or whatever, and or someone to challenge them, as opposed to drawing a line in the sand and, as I think they're trying to do, save money and get things moving on the low end, right?
Well, there are a few problems with that, Judge Piggott. One is that it's not the Board's job to draw the line in the sand.
No, but if you look at it the other way, I think of the ALJs who don't believe in acupuncture at all. They think that's a joke. They think that's an excuse, and they will not grant it. So now you're stuck with an ALJ somewhere who says, I'm not authorizing this at all, and you're out. Now, that's not going to happen anymore because there's a guideline that says it is a good procedure and you've got to give it. So there are benefits to this that, on the whole, considering the number, you say 20,000 variances, I don't know how many cases there are a month in the Workers' Compensation Board, but it's more than 20,000. And somebody's got to decide these things, right?
Right, and that implicates the due process issue, which is that if one individual worker runs into one individual ALJ who doesn't believe in a form of treatment or doesn't believe in a particular doctor, the ALJ, the worker gets to have their day in court on their treatment request.
So how is it going to work now under your interpretation of this, the guidelines and the presumption that it makes after the guidelines as being contrary to the statute? How is it going to work now in those 20,000?
It would work the way the legislature directed. The Board can use its existing medical treatment guidelines as a list of pre-authorized procedures, and for any treatment in excess of the guidelines, up to $1,000, there's no pre-authorization. The carrier can always object to the bill, not the Board, the carrier. Right. Over $1,000, if there's a request, the carrier can deny the request based on what the statute says, contrary medical
So we
opinion.
don't have to invalidate the entire guidelines if we agree with you?
Yes, Your Honor. Only the pre-denial portion of it.
Before you go on that, though, because you say you spend a lot of time in workers' compensation boards, how long do some of these hearings last when you've got an initial appearance and or a continuation? Sometimes 10 seconds, sometimes 30?
If counsel is well prepared, we can handle a hearing in about 2 minutes, Your Honor.
Right, and that's the way comp generally works.
Yes, Your Honor.
So it's only when you run into a situation that there's any type of a real hearing like you had here.
Right, and then what happens in this case is from the day the variance request was submitted until the day of the judge's decision was 3 months in which the lady got no treatment, and then you had an appeal which took 8 months, which is fast for the Board. They're now running about a year, during which she got no treatment.
What would have happened in the old days if it's more than $1,000? you would have submitted your request to the carrier, and the carrier, what, had a
30 days.
Had 30 days to get back, and if he got back with a medical opinion, you might wait forever.
If they did nothing, then at the end of the 30 days, it was authorized as a matter of law. If they got an IME who said it was fine, then it was approved. If they had a doctor who said it wasn't necessary, then we litigated.
Okay, so
And we litigate now.
So the occasion for litigation used to be the carrier saying no with an IME to support him. Now the occasion is if it's outside the guidelines.
That's exactly correct, Your Honor.
Okay.
Thank you.
Thanks, counsel. Thank you all. Appreciate it.